to deal with circumstances that are in the public interest where the prohibition is not necessary. Which brings me back to the question that I think has been put to you this morning by my colleagues. What is it then, since 56 protects from overbreadth, arbitrariness, and disproportionality in the face of evidence of the help you get to life, liberty, and security of the person in granting that exemption, why isn't it a violation of Section 7 not to grant that exemption?
Well, I'll say this much. I certainly agree with the premise that Section 56 may be regarded as a so-called safety valve, okay? So that Section 4 of the CDSA creates an offense and Section 56 gives flexibility. And that's the same reasoning that I think Justices Binney and LaBelle invoked in the Chaouli case with reference to the opting out, the ability to go to another province to obtain health care. And to say, well, you don't strike down the entire statute if there's a safety valve, this mechanism. And what Justices LaBelle and Binney said in Chaouli on that point is that you would address failures in respect of that safety valve at the implementational level. In other words, judicial review. Okay? And that's not what we have here. We don't have judicial review. The decision of the minister has not been made.
I just conclude, or before you conclude, ask you a concluding question on exactly that point.
Yes.
You've consistently said the minister hasn't made a decision. We have in the material the then minister's statement to the Standing Committee on Health on May 29, 2008. And it was a decision explaining why he was going to request the Minister of Justice to appeal Justice Pitfield's decision. It's very clear from all of those pages that he is not in favor of the supervised injection site and says so. In my opinion, supervised injection is not medicine. It doesn't heal accordingly, and he goes through all of the reasons he is not in favor of protecting Insite. Can we not, from a minister's comments to the Standing Committee on Health, conclude that a decision has been made not to extend?
Right. Well, my recollection of what was said in those committee statements is that the minister also said that he had a duty to consider the application when it was brought and to consider the material that was placed before him in reference to the application, and that he would do that. And he said he had to consider the public policy elements. So he's made that clear. That was, I guess, an expression of his concerns, but he made it clear, and I'll have the response in reply if I can dig it up. But he made it clear that he would consider the application as he had a duty to do, and he would examine the evidence that was presented, and that he would make a decision. And he also indicated that he'd consider the public policy. And so
the illicit drugs which are being injected as part of harm reduction at the supervised injection site are harmful to human health. There is no debate about this.
There's no question that injection drugs are harmful to human health. But my point is that the minister said, the then minister said, that he had a duty to consider the evidence and the material placed before him, and he would do that. And he also said he would consider the public policy.
But hasn't the court said on frequent occasions that it's not good enough to say, well, there's a discretion? I mean, if the rights are at issue here, don't we have to look at the situation saying, well, suppose the minister doesn't exercise his discretion? You're left with an absolute prohibition. Everything not permitted is prohibited. Right. And that's essentially a prohibition that we're talking about.
I think in my submission, if we look at Little Sisters and even what was said by certain members of the court in Chaouli, that a decision by a minister that's discretionary, that requires consideration of charter interests, it has to comport with charter values, and it's subject to judicial review on that basis. And it's reviewed at I think what was referred to in Little Sisters as on the implementational level. And what I'm saying is that under administrative law, you would let that decision be made, and then you review it to see whether it comported with charter values. And that's what we have to say in response to that.
We also say in the Ahmed decision recently that discretion has to be if discretion is